right, so let's start off with this one. Okay, on the SCOTUS abortion case now set for December 1st, recall the question the judges agreed to hear was whether any prevailability abortion ban is unconstitutional. Mississippi is defining its 15-week ban and asking the court to reverse Roe Casey to accomplish that. On a sound understanding of the Constitution, the answer to the question presented in this case is clear, and the path to that answer is straight. Under the Constitution, may a state prohibit elective abortions before viability? Yes. Why? Because nothing in the constitutional text, history, or tradition supports a right to an abortion. Wow. Wow. This is Greenwald. Remember how Griswold? Remember how I talked to you guys about Griswold v. Connecticut? Who here remembers when I talked to you about Griswold v. Connecticut and the right to privacy? Who here remembers when they prosecuted a gynecologist for prescribing contraceptives? That's what they're really trying to attack. The right to buy contraceptives. Okay. Because nothing in the constitutional text, structure, history, or tradition supports a right to an abortion, prohibition on elective abortions is therefore constitutional if it satisfies the rational basis review that applies to all laws. This case is made hard only because Roe v. Wade and Planned Parenthood versus Casey hold that the Constitution protects a right to an abortion. Under those cases, a state law restricting abortion may not pose an undue burden on obtaining an abortion before viability. And before viability, this court has said a state may not maintain a prohibition of abortion. Despite the state's important interest in protecting unborn life and women's health, both courts below understood Roe and Casey to require them to strike down Mississippi's Gestational Age Act because it prohibits, with exceptions for life and health, abortion after 15 weeks gestation and thus before viability. Roe and Casey are thus at odds with the straightforward, constitutionally grounded answer to the question presented. So the question becomes whether this court should overrule those decisions. It should. The stare decisis case for overturning Roe and Casey is overwhelming. Roe and Casey are egregiously wrong. The conclusion that abortion is a constitutional right. Wow. Jesus Christ. Anti-abortion activists had a plan to get the Supreme Court. It worked. When Mississippi passed a law in early 2018 that banned nearly all abortions after 15 weeks of pregnancy, state officials and anti-abortion advocates knew it was unlikely to survive challenges to the lower courts. The goal was to get to the U.S. Supreme Court. The strategy worked. On Monday, the court announced it would hear the Mississippi case during next term and consider whether any ban on abortion before a fetus is viable, that is, before it can survive outside of a person's womb, is unconstitutional. Chat, there's absolutely no reason why the court should be hearing this case. There is absolutely no reason. You may not know this, chat, but the Supreme Court doesn't have to hear any cases. There's okay, that's not totally true. There's a few types of cases that go to the Supreme Court directly, but they're not relevant to what we're talking about, okay? An example of one of those cases, if a state sues another state in federal court, that goes to the Supreme Court automatically. But anyway, we're not talking about those fringe cases, okay? The Supreme Court doesn't have to take a case. In fact, they don't take most cases. The vast majority of cases they don't take. You're only guaranteed an appeal up to the circuit court. Why? When does the Supreme Court take a case? The Supreme Court takes a case if there's something known as a circuit split, because there's 13 circuits in America. There's 13 appellate courts, and they have jurisdiction over their states within their territory, and they can have different decisions. So say in one district, it says that abortion is constitutional, or abortion rights are in the Constitution. Another circuit, it says it isn't. Well, the Supreme Court might take that case to resolve the circuit split. All right? There is absolutely no reason whatsoever to take up an abortion case. This is clearly precedent from Planned Parenthood versus Casey that this is an unconstitutional law. It's been settled. It's been decided. It's clear. The only reason the Supreme Court is taking this case is to overturn this fucking right, to overturn their previous decisions in Roe v. Wade and Planned Parenthood versus Casey. This is insane. It's a question that lower courts had considered settled as they repeatedly blocked the Mississippi law and other similar bans that were enacted in more than 10 states during the Trump administration. That the court is taking up the Mississippi case is a sign that at least some of the justices are open to revisiting and potentially dismantling abortion rights that has been established for decades. It's also the first major abortion case the court will hear since Amy Coney Barrett was confirmed in October 2020, deepening the conservative majority to 6-3. The effort to get abortion back before the Supreme Court took shape shortly after Donald Trump won the presidency in 2016. In a bid to gain the powerful endorsements of major figures in the evangelical and Catholic communities, the former president vowed to focus on repealing abortion rights and overturning Roe v. Wade by appointing conservative justices with anti-abortion views. Who agreed? Which justice accepted? So for the Supreme Court to hear a case, 4 judges have to vote. 4 judges have to vote for the case to be heard. Wait, what? Over the next 4 years, which saw the confirmation of 3 conservative justices, Barrett, Neal, Gorsuch, and Brett Kavanaugh, state legislatures sent a string of pre-viability abortion bans and other anti-abortion laws to the desks of Republican governors. In 2019 alone, 12 governors signed 58 restrictive laws, ranging from requiring doctors to read a script containing anti-abortion information ahead of the procedure to imposing blanket bans on abortions after 6 weeks of pregnancy. Abortion rights groups very wary of teeing up cases for a solidly conservative Supreme Court to revisit the protections of Roe and other abortion rights cases found themselves caught in a bind to let the bans pass in a small number of states, limiting abortion access for thousands of women, or to play into the plans of anti-abortion activists and file lawsuits that would give conservatives a way to pitch the issue to the justices, potentially impacting abortion rights nationwide. They chose the latter, hoping the Supreme Court refused to take up the bans at all. Already, abortion is nearly impossible to access for people in states like Mississippi, where lawmakers have been chipping away at the right to an abortion for decades. We will keep fighting to make sure that people do not lose this fundamental right to control their own bodies and futures. Do you think any of these anti-abortion laws will come back to bite the Republicans in the foot near midterm? I mean, considering their stance is generally unpopular. I don't know anymore. Because, like, I think it would. But people are in these fucking bubbles now, man. Across the nation, state lawmakers acting on the will of the people, aka gerrymandered districts, have introduced 536 pro-life bill aimed at humanizing our laws and challenging the radical status quo imposed by Roe. It is time for the Supreme Court to catch up to scientific reality and the resulting consensus of the American people as expressed in its elections and policy. As Marjorie Dannenfelser, president of the Susan B. Anthony list. The Mississippi law, the Gestational Age Act, contains exceptions to the ban in cases of fetal abnormalities and medical emergencies, including a threat to a person's life or serious risk of physical impairment, but not in cases of pregnancy from rape or incest. The court's frustration in part is that other states have already unsuccessfully litigated the same sort of ban that this is before this court, and the state is aware that this type of litigation costs the taxpayers a tremendous amount of money. No, the real reason we are here is simple. The state chose to pass a law and knew it was unconstitutional to endorse a decades-long campaign fueled by national interest groups to ask the Supreme Court to overturn Roe v. Wade. Even Judge James Ho, who was confirmed to the Fifth Circuit under Trump and swiftly established himself as a leading conservative voice on the federal bench, wrote separately to indicate he was sympathetic to Mississippi lawmakers but was required to uphold the ruling against the state. Ho noted that Mississippi's lawyers hadn't asked the court to hold oral arguments, a sign that the state expected to lose on its way to getting to the Supreme Court. And they've now announced that they're doing it in December 1st. I'm told SCOTUS will not be issuing day passes to journalists who don't have hard passes to cover December 1st args in person in the Mississippi abortion ban case, citing health safety reasons. Jesus Christ. A legal scholar on YouTube explained that Roe v. Wade is about to be dead, but that Planned Parenthood versus Casey is the law of land people usually use. Is that true, or is it still be a problem? They're going to overturn both. Planned Parenthood depends on Roe. They're not going to overturn Roe and leave Planned Parenthood. Planned Parenthood is the standard that's actually being applied. People say Roe because that is the case that established the right to an abortion. They're also going to appeal Planned Parenthood versus Casey. They're not going to go, whoops, we forgot Planned Parenthood. Guess we can't ban abortion.